Welcome to the Connecticut Judicial Branch Law Library's Self-Represented Parties Information Series. Connecticut Superior Court Civil Lawsuit, Objection. In this overview, we will discuss the reasons and general procedures for writing and filing an objection in a Connecticut Superior Court civil lawsuit. Getting in touch with a lawyer to help you is a good idea. But if you decide to act as your own lawyer, the following is information to know. Some words to know. An objection is a formal statement of protest, usually written, during the pretrial process in opposition to or in disagreement with a motion, request, or other pleading filed by an opposing party or in opposition to a court proceeding or ruling. An objection challenges or disagrees with the claims or arguments in the opposing party's pleading and asks the court to decide or rule against the opposing party. Pleading is a motion, objection, or paper filed in a case, usually written, asking or requesting the court to make a decision or judgment on something. It is filed in the clerk's office. Party is the word for a person, business, or governmental entity that is involved in a lawsuit either as a defendant or plaintiff. Short calendar for arguable matters refers to a court session in which a judge holds a hearing or listens to oral arguments on pleadings, motions, or objections and issues a ruling. A hearing is required for some motions and objections. Other motions may not require a hearing, but a party can request one. Court forms. Some court forms or pleadings are pre-printed and available on the Judicial Branch's official court web forms page. These include a few frequently used motions for civil, family, and housing courts. However, many pleadings do not exist as pre-printed forms and must be written by the party. Except for 3 specific foreclosure and housing forms, an objection is a pleading you must write yourself. Connecticut Practice Book. The Connecticut Practice Book, also referred to as simply the Practice Book, has several chapters you will want to review regarding pleadings, including objections. Many of your basic questions on how to write and file a pleading may be answered by the Practice Book. Chapter 4, Pleadings, provides information on how to format or set up a document that will be filed with the court. It instructs on the size of the paper to use and what to include in the heading. Section 4-1D states that the clerk may require a party to resubmit a motion that does not properly follow the rules. Chapter 11, Motions, provides more information on what to include in a written motion or objection. In the appendix of forms of the practice book, you will find Form 101, which provides an example of how to set up the motion or objection heading to comply with the court rules. In the next few slides, we will go over how to set up and write an objection. Heading. The heading of an objection includes the docket number, the name of the case, the court where the matter is being held, and the date of the objection. Follow the example provided in the practice book, Appendix of Forms, Form 101. On the left side of the heading, type the docket number. 2 spaces down from the docket number, type the name of the plaintiff, the party who is doing the suing. 2 spaces below the plaintiff's name, type the letter V followed by a period. The V stands for versus, which means against. 2 spaces below the V, type the name of the defendant, the person who is being sued. On the right side of the heading, type the court name and date. Across from the docket number, on the right side, type Superior Court. Across from the plaintiff's name, on the right side, type the Judicial District or GA, Geographical Area, number. For example, Judicial District of Hartford or GA 14. Across from the V, type at and the location of the courthouse. For example, Judicial District of Litchfield at Torrington or GA 12 at Manchester. 2 spaces below at and across from the defendant's name, type the date of the objection. The heading is followed by the title of the objection. 2 spaces below the heading in the center of the document, type the title of the objection. Usually, an objection is titled Objection to, followed by the title of the pleading or motion you are objecting to. The title of an objection also identifies the party who filed the pleading or motion that you are objecting. For example, if you are objecting to a plaintiff's motion to transfer, you would title your pleading Objection to Plaintiff's Motion to Transfer. Objection titles are generally typed in all capital letters and underlined. For our example, the parties are Jane Jones as the plaintiff and John Jones as the defendant. The court is the Judicial District of Fairfield at Bridgeport. The date is April 8, 2020. The title of our motion is Objection to the Plaintiff's Motion to Transfer. How to write the text of an objection. Since each case includes unique details, each pleading or objection also may include unique details. It can be difficult to find samples or examples of pleadings or objections that say exactly what you will want or need to say. However, there are a few publications which provide some sample language or examples of objections which can guide you as you write your own objection. But often you will need to write your objection without a sample or example. Overall, when writing an objection, you will want to keep it simple and direct. Tell the court what part of the opposing party's pleading you object to and exactly why you object to it. Format your objection by first repeating the opposing party's claim or request, then stating why you disagree with that claim or request. Connecticut Practice Book Section 10-1 states, each pleading shall contain a plain and concise statement. Keep your objection simple. Clearly tell the court what you are objecting to and why. Include only information that is important and will help the court to make a decision. You can visit or contact a Judicial Branch Law Library to conduct research to see if a pre-printed samples or examples of an objection are available. Text of an objection to a motion to transfer. In the opening sentence of an objection, you usually begin by providing your name and indicating whether you are the plaintiff or the defendant. The opening sentence also contains a brief statement of what pleading you are objecting to. For example, this objection to the plaintiff's motion to transfer begins, "The defendant, John Jones, objects to the plaintiff's motion to transfer for the following reason." The objection then states the reason for the objection to the plaintiff's motion. Signature. Connecticut Practice Book Section 4-2. Each pleading or objection must be signed by the party submitting the pleading or objection. Practice Book Section 4-2 states the rule that applies to the signing of pleadings. Make sure you are in compliance with Practice Book Section 4-7 regarding personal identifying information if it applies to your objection. The signature portion of an objection should appear on the right side of the document following the text of your objection. It begins with indicating if you are the plaintiff or defendant. Below this indication is your signature itself. Below your signature, type your name. Below your name, type your address. Below your address, type your telephone number. In our example, the defendant, John Jones, will sign on the line and his name, address, and phone number are typed below his signature. Oral Argument Testimony. Connecticut Practice Book Section 11-18. Connecticut Practice Book Section 11-18 states that oral argument is at the discretion of the judicial authority, except for a few select motions as listed in the rule where oral argument is required. Most motions and objections do not require oral argument. In most instances, Except for those motions listed in Rule 11-18, the judge will rule upon the pleadings and objections filed by the parties after reading them. There is no hearing, and the parties do not need to come to court or appear remotely. Oral argument is when a hearing is held and you and the other party or parties present the reasons why the judge should rule in favor of one party or the other on the issues identified in the pleading or objection. In most instances, oral argument must be requested. Oral argument will take place during a short calendar session. The court will assign the date for the short calendar session, and the parties will need to follow the procedures for short calendar and mark the pleading and objection as required. Short calendar sessions for arguable matters may be conducted in a courtroom or remotely. The judge may ask questions to make sure he or she understands your argument. The judge can make a ruling at that time from the bench or may issue a written ruling later. In your objection, below the signature and address on the left side of the page, indicate that you are requesting oral argument or testimony by typing "Oral argument is requested," and below that, "Testimony is required." These statements are generally typed in capital letters. It is not necessary to insert these notations if oral argument or testimony is not requested. Certification. Connecticut Practice Book Sections 10-12 to 10-17. Practice Book Section 10-14 states, proof of service pursuant to Section 10-12A and B may be made by certificate of counsel for the party filing the pleading or paper or by the self-represented party. The certification section of the objection is where you confirm to the court that you have provided a copy of your objection to all other parties of record. The certification appears on a separate page, following the signature portion of the objection. Copies of the objection may be provided to the other party or parties by United States mail or by electronic delivery if the parties have already agreed to this form of service. You should deliver the objection to the other party or parties before you file the objection or on the same day. You should not deliver the objection to the other party or parties on a day that falls after the filing day. Memorandum of Law. A memorandum of law is a written document that must be filed along with some pleadings. If a motion or request requires a memorandum of law, then the objection filed in response to that motion or request must also include a memorandum of law. The memorandum of law explains to the court the legal reason why the court should agree with your objection to the opposing party's motion or request. A memorandum of law must include the facts of the case, the legal reason or argument that supports the objection, and the laws, rules, or other court cases that show the objection is correct. Connecticut Practice Book Section 11-10 talks about the memorandum of law and which pleadings require one. Short calendar. Sections 11-13 to 11-19 of the practice book talk about the short calendar. Section 11-13 states, unless otherwise provided in these rules or ordered by the judicial authority, all issues of law must be placed on the short calendar list. Civil short calendars are issued by each judicial district. Separate calendars are issued for arguable matters and non-arguable matters. To have the motion and your objection acted upon, the short calendar notice marking instructions must be followed. If a matter is on the non-arguable short calendar, the judge will rule or decide on it after reading the filed pleading and objection. This is referred to as take papers. It is the responsibility of the parties to make sure that the short calendar marking procedures are followed, so the judge will know that the pleading and objection are ready for him or her to review. Once the pleading and objection are ready, the judge will have 120 days to issue a ruling. The arguable short calendar is a list of matters for which a hearing by a judge or magistrate is requested or required. Short calendar sessions for arguable matters may be conducted in a courtroom or remotely. Several cases are scheduled during short calendar, and the judge or magistrate will address them one at a time. At the hearing, the judge or magistrate will hear the arguments for the motion and objection. He or she will either issue a ruling or order at that time from the bench, or provide a written ruling or order within 120 days following the hearing. The judge can decide to grant or deny a pleading or objection in whole or in part. In whole is when the entire pleading or objection is granted. In part is when the pleading or objection is only partially granted. It is not uncommon for a judge to grant a pleading or objection in part. It is very important to read the ruling completely and make sure you understand exactly what the judge has granted and what he or she has denied. It is the responsibility of both the plaintiff and defendant to read the ruling and comply with, or follow, the judge's directive. Failing to do so can hurt your case. Reading the ruling also helps you to decide how to move forward or proceed with your case. This is the end of our overview. For more information, please visit or contact a Judicial Branch Law Library, a Court Service Center, or the Judicial Branch website.